you're not new in town, but are you, the rest of you kind of new to town, or? I know you're not new to town either. No, nobody's new to town.
2 years.
Yeah, 2 years.
That's new to town. I don't recognize any of you, so you must be not new.
Well, they're quite glad you don't recognize them.
Yeah, exactly. I'm not a good person to see. So my title is that I'm the Assistant District Attorney for the 7th Judicial District, which is a 6-county area which spans from here all the way over to Gunnison County, and we have 4 different offices. I'm like the vice principal, so I'm mostly here in Telluride, but I also go to other courts quite frequently, so I'm sort of all over the place, and I deal with employment stuff. And I've been prosecuting here in Telluride since 2002, and that's a long time to be a prosecutor. I think I win the record for being a prosecutor in Telluride, by far. And so I've been dealing with, or working on, I shouldn't say dealing with, working on and with domestic violence and domestic violence victims for a long time now. Do you guys all know what domestic violence means in the criminal context? What does it mean? You're nodding your head. Let's hear from you.
We have it on our sheet.
Yeah. So it's actually a sentence enhancer, and it's not its own crime. So you don't get arrested just for domestic violence. It has to be with something. So it's either usually harassment or assault or criminal mischief, something like that. And so once I get one of those cases, the way it works is that, do you want me to go through all of this?
Can you just elaborate on that one thing right there?
Which?
You said you couldn't get arrested for domestic violence. It has to have a combination of other things.
Correct. It has to be an underlying crime. So, and it can be almost any crime so long as it's with an intimate partner, a former intimate partner, and that it's used as a method of coercion, control, power. So you do have to prove that piece, or the judge has to make a determination that that piece is present. And if it is, then, and there's conviction, then the individual is required to take domestic violence counseling. So that's what they're required to do. And the other thing that it does is that it makes any crime a Victims' Rights Act crime. So that means that we then let the victim know of every stage of the proceedings, critical stages of the proceedings. We let them know about bonds. We talk to them about protection orders, and once you're arrested on a domestic violence case, you are on a no bond hold. You have to stay in jail with no bond until you're seen by the court. And the bond is then set. So if you're arrested, for example, we only have court here on Tuesdays. If you're arrested on a Thursday night even, you may not see a judge until Tuesday. Go ahead.
I just have a question.
Sure.
So, because Colorado has a mandatory arrest policy, if police are called to domestic violence situation, the arrest is actually for a specific assault, and then domestic violence gets tacked onto that?
Correct. And so they write what's called a warrantless arrest affidavit, and it'll say whatever the crime was on there. And again, the typical ones are harassment, which is push, assault, which is any kind of punching. Really, it can be pretty serious. It can be up to felony assault, or also criminal mischief. They're throwing stuff around, breaking things. That's a very typical one as well. And so the arresting officer will make a determination about the charge of this domestic violence and this individual under arrest. So if they have probable cause, did you guys already speak with an officer yet, or?
They're coming in now.
Okay. All right. So they'll let you know a little bit about that. We do have different perspectives on some of those things, but if they have probable cause, then they are required to arrest. And hopefully they don't arrest both parties. They've gotten really pretty good about not doing that, but sometimes it's very difficult to tell who the primary aggressor is. And it just is. I mean, it's hard. It's a very difficult job. There are certain factors we can look at, certain types of evidence that they have to collect. So then once somebody's in our system, the suspect is arrested, then we pick it up on in our office the next business day, and then we start contacting the victim, and hopefully we can get in touch with that person. And then they let us know what they would like on their protection order. So that's the point at which we have a criminal protection order put into place prior to the defendant bonding out. And there can be no contact with the victim. If there's a child present, we will often ask for no contact with the child. drinking, I'll ask for no drinking. I usually ask for no alcohol, just anyway. It almost always includes alcohol, unfortunately. No firearms, are not allowed to have firearms. In fact, you have to relinquish your firearms now within 72 hours if you are arrested on a domestic violence case. And any firearms or ammunition, and you have to file a certificate with court. So they've gotten fairly strict about that. And if the defendant does not comply with that, then it's a protection order violation, a criminal protection order violation, which is a class 1 misdemeanor, which is our highest level of misdemeanor crime. So there are kind of a lot of things that get put in place because of the domestic violence designation. Does anybody have, I just said a lot of things, does anybody have any questions about that? Nothing. So sometimes at that, just to weave in the resource center, you all are private advocates, which is different than a public advocate. We also have public advocates sometimes, or law enforcement advocates that work with victims, and information provided to law enforcement advocates are not confidential. There's not a privilege, they're not privileged communications. So anything that a victim says to you all are privileged communications, and you can't tell me what they said, even if it might be super helpful to the case. But there are times when we will speak with staff here to ask about protection order issues, or even just to help us find somebody, that kind of thing. And if the person has waived the privilege, then they can let us know. But at every single court hearing, I guess you guys must just kind of know what's on the docket or something. You just kind
Yeah,
of
we
look
print
it
out
up.
the docket every Monday
Mhm.
and look and see if anything has come through our office. Usually, if it's any sort of domestic violence charge, we try to go to the hearing just to see what's going on, just to keep it on our radar.
So it's even if it's not your client, you go
Mhm.
anyway just to see, and then you take statistics about outcomes and things like that.
That's a question for Rachel, because I actually don't know.
Okay. I haven't seen her there recently.
Well, she is no longer with us, but she's,
Oh, okay.
we don't have anybody else right now.
I see.
Besides Angela, so.
Okay. All
Keri,
right.
I guess my big confusion about the whole thing is legal advice or lack thereof, or what is we as advocates, what are our boundaries, and what should we look out for giving advice? Or
Well, I mean, I'm not sure you're there necessarily to give advice. You're probably there to give direction or resources, other resources. So the resources we have that I can tell you about are that I kind of do a lot of my own victims work, so I actually speak with victims all the time myself. I call them up, I take their phone calls, so they can call me directly if they have any questions. We also have an advocate in Montrose, and a couple of them, and we have what's called crime victims compensation. So we provide therapy. If there are any medical bills, we'll pay for those. It's not really technically part of our office. It's kind of confusing. It's another pot of government monies, but it comes through our office, and so they can apply through it. We can point them in the right direction. So that's the kind of thing I would do, is kind of tell them what's out there, because honestly, a lot of the time we lose the victims right away. It's almost always. If I lose them, I mean they become disinterested, frightened, or just completely recant. In almost all my cases. In fact, I don't know if I have one right now that wants to call me on the horn or anything. You know, and there are a lot of reasons for that. You're probably learning what those are, but it's really difficult. It's pretty difficult. So the other thing that we have here too, which is unique to this community, is that we have a lot of people who come and, as you know, are just visiting, and so they get in fights and drink too much. I've had a lot of this where they're on their honeymoon. It's really sad. They drink too much and beat each other up, or usually one's more at fault than the other. But then once they leave, I actually have a power to subpoena them to bring them back, but it's very difficult. So there are a lot of those that kind of slip through the cracks, unfortunately, because I just can't get the victim back. And I can't, because of the rules of evidence, I can't prove a case unless there's another witness or there's some other way to get that evidence in. And so almost all the time in these cases, I need the victim to actually come and testify. I don't want to. So, but we've had some pretty bad ones. I've had a really pretty bad one this year. I have been in contact off and on. And I just talked to one the other day. I mean, a lot of times I'm having to use the same skills that you guys are, which is just trying to calm them down and reassure them that it's going to be okay. You know, they don't want to come and they don't want to face the defendant in court, and they don't want to put their lives on hold and come over. So I have to kind of walk them through that. So I spend a lot of my time doing things like that. Any other questions? Go ahead.
When you have a victim recant, say, oh, or I don't know if that's the word, not
Yeah.
recant, I don't want to press charges.
Right.
And you've already talked to them, you know what happened. How do you react? Are you just like, okay, that's your choice?
I say, I understand, this is a conversation I have all the time. I understand that you probably don't want to proceed with this, but it is my decision, and you can let so-and-so know that it's my decision and that I'm telling you that I'm going forward because there's enough evidence in this case. And so, and we don't have a billion trials with them, but I've had several, and what happens in that scenario is that hopefully I have some kind of written statement or photographs or something, and then I'm able to impeach them with that information. It's pretty uncomfortable because sometimes they're lying and things like that on the stand. Or sometimes they'll just simply say, I don't remember what happened. And that's the same effect. I can then bring up their prior statements. I can then bring in officers who said, yeah, I saw her on this night. She was really upset. This is what she told me. Any 911 calls are critical for that. So we have to do a lot of things like that. But that's something that happens all the time. And then I have to actually disclose that to the defense to let them know that they don't want to proceed. But it is really up to us. So on any criminal case, it's not up to somebody to press or drop charges, even though that language is still used even by some law enforcement. And so it's confusing to people. But it really is our decision. It's a public safety issue is what it is. That's how we view it, even though people view it as it's their business. We don't view it that way.
We as advocates can't subpoena it though, right?
That's correct. There's a specific statute in place for private advocates that puts there's a privileged communication. So if you're ever subpoenaed, then I don't know who you use as a lawyer, but you can move to quash the subpoena. We have had defense attorneys try stuff like that before, but they can't do that. Go ahead.
In the case of people who leave or go back home or whatever, is there a way to kind of work with them, or once they're out of the county, it's just like...
No, we do work with them if we know how to get a hold of them. So obviously most people nowadays have a cell phone, so if we have that, then we'll call them. And if we have a good address on them, or even a town or city, then we'll be able usually to find them. But
So people, like if they wanted to proceed with charges, they would travel back and it would be tried in this county?
Correct. And if they don't want to proceed with charges, but I think it's a good case, then we will subpoena them there, and that requires a lot of legwork on our part. I had one that we did last year where it was in New Mexico, and it's really difficult dealing with these other foreign jurisdictions because they have different rules and regulations, and they put a lot of orders on us about what we had to pay for. And I mean, they were really feisty. We had to pay a lot of money to bring these people back, but we can do it. We have that power. So.
It seems like if you had, maybe not like a domestic situation, but like a sexual assault situation where it was like a predator like situation, then you would want someone to come back.
Right.
More
Yes.
so that it's like a couple that gets into a fight while they're here on vacation.
Right. But even then, I'll do it if it's a push shove or something. I do draw a line sometimes, because it's money that we have to spend to bring people back and put them up. I just had a harassment case. It wasn't even domestic violence. We spent over $3,000 bringing somebody back just to testify. But our policy is that we're not going to not do something because of the money issue. So we do it. We have to. And the state covers some of those costs. So there are two different kinds of courts. I'll just keep talking until how long am I supposed to go? Okay. So we have county court and district court. And county court handles all of our misdemeanor cases, and district court handles any felonies that we may have. So if we have a felony domestic violence case, it'll start out in county court, but then it'll go down over to district court where it will be heard by a separate judge. And that's, for felonies, you can be put in prison, and there's higher consequences and things like that. And we do have, I have at least one ongoing felony domestic violence case right now. It's a pretty serious one. And just in terms of numbers, we have been having, I feel like we've been having at least 1 or 2 a week lately. So it's, you know, we have quite a few cases. Looks like Whitey's here to talk to you. So does anybody have any questions about what I do, or you guys all know if I give you a quiz right now about the court system, you can go pass. And just real quick, that you were asking about protection order earlier, so I was talking about the criminal protection order and how we put that in place at the beginning of the case. That will remain in effect for the entirety of the case, meaning that if the defendant is placed on probation, it will remain in effect for 1 or 2 years of probation. If it's dismissed, it goes away. But if you get a civil protection order, then that is forever if you're able to get it. They're not that easy to get. You have to show continuing threat. Usually if it's your typical domestic violence case, you should be able to get one, but they're not that generous about giving those out anymore. I don't know if you found that, Crystal, or if you've been to any recently where they haven't given one on a permanent.
Not recently.
Yeah, it happens. So, and the other thing is that that's not reverse. It is reversible, but it's a lot harder to reverse. So somebody really needs to be sure that that's what they want to do before they do it.
If one judge says no, can someone go to another judge?
Well, we're only supposed to have one judge here, but as we know, they kind of do rotate in and out. But jurisdictionally, if it happens here, you have to see our county court judge. So the short answer is no, but maybe you could find somebody else filling in one fine day. With the criminal protection orders, those are easier to change. I don't really like doing it, but if somebody changes their mind and either wants no contact or wants to take it off, then I'll do it depending on the circumstances. And that's when I usually send them to the resource center to do some kind of safety plan. All right, any questions about that? You guys can